The civil procedure problem from July of 1990 was very unpopular with a lot of people that had to write answers on that bar exam, and it's not hard to see why. This is a hard civil procedure problem to the extent that any of them are hard. And the reason it is difficult is because it is testing some tricky issues that are a little bit out of the ordinary and that challenge us to really know the law. Take a look at the call of the question. We see that it is a 5-part call of the question. And that's good news, because that means when it's all said and done, we're really only being asked to write short answers to pretty straightforward questions. And as we get into it, we'll see that our knowledge of how the subject is structured will help us organize a fairly thorough and meticulous answer under time constraints. So let's review the calls of the question. 1. Were the court's rulings correct as to D's pretrial motion to dismiss? Discuss. Well, it's hard to say what that will be about. Perhaps jurisdiction, perhaps something else. 2. Leisure's pretrial motion to dismiss. Discuss. Again, one would expect a jurisdiction claim, but we'll wait and see. 3. D's motion to implead IMCO. Discuss. Well, the impleader law is tested fairly commonly on California Bar Civ Pro essays, and we'll see. Once we get into it, it makes a fair amount of sense. The great thing about civil procedure is, at least to my way of thinking, none of it is counterintuitive. Call of the question 4. IMCO's pretrial motion to dismiss. So it looks like everybody is making a motion to dismiss before a trial. We'll think again. Perhaps jurisdiction, perhaps something else. And then number 5, the post-trial motions to dismiss. Well, that's a little unconventional, and it's hard to even hazard a guess about what that's all about before we read the fact pattern. So let's go up to the top and review what's going on here and see how quickly we can set up our analysis. In paragraph 1, we meet Pat. It turns out Pat's our plaintiff, but we don't hear anything about Pat in the call of the question. So Pat is a resident of State A. Pat purchases a hot tub from Leisure, the second named defendant, or at least the party named in the second call of the question. And we find out about Leisure's advertising practices because it gives us a hint as to contacts. And we also find out about this defendant's sale of hot tubs in the various different states. In paragraph 2, we find out that Pat suffers harm. The hot tub overheats, Pat is scalded, and water damages Pat's property. So the predictable lawsuit arises in the 3rd paragraph. Pat sues in federal court using diversity jurisdiction in State A federal court against both Leisure and against D. And as a result, the action is joined. We notice that the complaint is filed right before the applicable State A statute of limitations, and we have a long-arm statute mentioned. And service doesn't actually reach Leisure for 3 weeks, beyond the statutory period. So, in paragraph 4, D moves for dismissal based on personal jurisdiction. Well, we know what the elements of personal jurisdiction are. We need a long-arm statute, and then purposeful availment, foreseeability, and fairness. Our 3-part analysis. So, if that's what D's pretrial motion is about, we can outline our answer to the first call of the question right now. So, I would advise you to do so. We move on to paragraph 5, and we've got Leisure making a pretrial motion for summary judgment based on the statute of limitations. This motion is denied, and this is a complicated question, and we're going to go into some fairly serious analysis when we get to a review of the answer. Notice that we've got a choice of law issue in a diversity case. That means an Erie issue. In the following paragraph, we have the impleader facts. D wants to implead IMCO, and D is alleging that the thermostat supplied by IMCO actually caused the injuries to the plaintiff. And this motion to implead was granted. Here, we will examine an issue that comes up pretty often in civil procedure essays, supplemental jurisdiction. It's a pretty straightforward issue, and our analysis will not be difficult to follow. So then we have Pat amending his complaint to add IMCO with a motion to dismiss from IMCO coming in reply. Finally, we've got a verdict from the jury, a $45,000 verdict, and a motion to dismiss based on the amount in controversy requirement. Remember, back in 1990, the diversity amount was $50,000 rather than its current higher amount. So turn the page and take a quick look at my outline of issues. Here, you'll see it's very straightforward. Our framework of analysis for question 1 is based on our basic minimum contacts analysis. In Roman numeral number 2, the pretrial motion for summary judgment, first we begin with reciting the summary judgment rules, then we move on to consider Erie and to apply it to the case at bar. Then we have a separately headed conclusion. With regard to D's motion to implead, we must consider supplemental jurisdiction. This doesn't lend itself to any real internal organization, but that's no surprise. We've got a 5-part call of the question. By its nature, it's much more likely to be short answers than something that's closer to being a real essay. Next, we've got IMCO's pretrial motion to dismiss in Part 4. Here we deal with each of the separate prayers, the motion to dismiss the whole action, or merely Pat's claim as to IMCO. Then, finally, the post-trial motions to dismiss. This is very straightforward, and I would say that question 5 is the easiest one to analyze. We'll also see I don't spend a whole lot of time on it in the answer. Well, that's it for the framework of analysis. Now let's take a look at the answer that I provide. There are 1 or 2 points that are worth our paying a little bit of additional attention to, the issues that we haven't looked at before and that remain fair game on SIFPro essays. First, we look at D's pretrial motion to dismiss. Notice how in the first paragraph, as usual, I lead with the facts. I set the stage procedurally for what's going on, and I even indicate obliquely what the applicable law is. Then I focus on the notice issue, and then I go to minimum contacts. Here you'll see I follow the basic format about purposeful availment, foreseeability, and fairness. I don't have internal headings for those line items because I just don't think there's time given the pressures of the question. If you were able to find the time and break it up into those pieces, I think that is successful and desirable. But, you see, I didn't choose to do it, and I don't think there's any problem one way or the other. This is a racehorse question, and the grader is going to know where to look to see if you're hitting the issues. Ultimately, I conclude that the court's denial of D's motion was a correct decision. We move on to Leisure's pretrial motion for summary judgment. Here, we're dealing with the most complicated factual and legal issue presented in this question, the one dealing with the statute of limitations and Erie. If you don't yet know this law, study this question and answer carefully, and look up the material if it still doesn't make much sense. It's quite possible that this issue could be on your bar exam, and it is well worth being clearly briefed on the issue and how it works. So, you see again, I set up the facts about the situation, procedurally and substantively. Then I move to the summary judgment requirements, and I focus on Erie. Once we get to Erie, you'll see I don't waste a whole lot of time with it. This part of the problem is kind of like cooking an Asian meal. It takes a lot longer to set it up than it takes to actually prepare. Here as well, setting up our analysis, both organizationally and in terms of providing the factual context, is a lot more difficult than actually answering the question. The bottom line is, there's a Supreme Court case on point. A state statute of limitations is substantive law, not procedural. So, the bottom line is that the district court's denial of the pretrial motion for summary judgment was wrong. Pat was not served with a complaint in a timely fashion, and so the lawsuit should be barred by the state A statute of limitations. We move on to Part 3, D's motion to implead IMCO. Here again, I lead with the facts, and I set up the procedural status of the case. Then we go into supplemental jurisdiction. Here, supplemental jurisdiction allows an indemnity claim to be litigated, even though the party being impleaded otherwise would break up diversity. The plaintiff can't bring this third party in, but the defendant can, for indemnification purposes. So this analysis really sort of sets up our analysis of Part 4, IMCO's pretrial motion to dismiss. Once again, I set up the factual and procedural status of this aspect of the litigation. The court previously has granted IMCO's motion to dismiss, but refused to dismiss the entire action. Well, let's look at it. The motion to dismiss the entire action comes first, and I conclude that the court was correct in refusing to dismiss the entire action. But with regard to Pat's claim against IMCO, here the court is correct because supplemental jurisdiction doesn't go this far. So, finally, we turn to the post-trial motions to dismiss, and here I don't talk about the parties bringing the motions separately because it's the same substantive issue. So, because Leisure and Dee are making the same motion, that doesn't mean we absolutely have to talk about them separately, and I don't. Here, it seems that the court made a clear error. The court granted these motions after the trial, when in fact the way that we judge the amount in controversy in diversity cases is whether or not the initial filing was made in good faith, not whether or not the jury's verdict is in conformance with that requirement. So this question is well worth our taking our time to review. It's hard because it has somewhat unconventional issues, and it has many issues. So, once again, the emphasis is placed on our ability to spot the issues, break them up into elements based on our knowledge of the law, and then apply the facts in a rational fashion to reach conclusions that make sense.